Okay, welcome everybody to our roundtable today. As many of you know, my name is Jim Steef, and I chair the McDonald Hopkins Commercial Finance Group. And today we're going to talk about maximizing the borrowing value of inventory, which I'll get to a little bit more in a second, but I want to introduce our panel to you. From the Commercial Finance Group here at McDonald Hopkins, we have Nathan Wiedemann to my far right. We have Jason Smith to my left, and then we also have Alex Sutton here from AccuVal. Alex is their vice president in charge of inventory valuation. And Alex, if you want to take a second or two to talk a little bit about your job at AccuVal.
Sure. I run our inventory appraisal practice group primarily 98% of the time for asset-based lending transactions. We do a little bit of fair value inventory valuation work as well for purchase price allocation and other purposes. I've headed the group for about 6 years. I've been in the appraisal and liquidation world for about 15. I've run some large inventory liquidations, including large furniture operations, some metals operations, and what else can I say? I work out in New York. We have about 20 professionals in our inventory appraisal practice, and AccuVal's headed out of Wisconsin, headquartered in Wisconsin.
Thanks, Alex. And then Jason, Nathan, and I, again, we work in the commercial finance group, and our primary responsibility is structuring and documenting complex loans from both the lender and the borrower side, and also senior debt, sub debt, and different types of real estate and other debt. The reason I bring that up is as we go along today, sort of some of the housekeeping notes is if you have questions along the way, we want this to be an open format. We're going to have you write down questions on the cards you have. And if you're on by webcast right now, there's an email or a tab on the website where you can actually type in a question and send it to me. Then Deborah, just raise your hand or raise your card with the question, and Deborah will grab it, and we'll have people grabbing them off of the computer, and she'll bring them up to me. If we can answer it, we will. We're going to try and keep this to about an hour. It might be a little short. We can always go over a few minutes if we have to. If we can't get to your question or don't get to your question, please come up and see us afterwards, and we can always get with you either later today or sometime in the near future to answer any questions that you have. And I think that's it as far as logistics. Let me give you a little bit of an overview of this roundtable and what we're trying to accomplish, and then we'll get into the detail. I think this is an important subject for both lenders and borrowers because what we're talking about is, most companies have inventory, and most loans these days are based on some valuation of assets, especially with what's happened to the economy over the last few years. If you're a borrower or a lender who's lending on a multiple of EBITDA, or you're taking a security interest in the assets but not basing a loan on the value of those assets, then this is not as important to you. I think it's important to understand what's happening, but what we're talking about is when a lender wants to lend or a borrower wants to borrow on the actual assets, on the actual value of certain of its assets, including inventory, then I think the tips we're going to give you today are going to help you understand ways to maximize what that borrowing value is. And so first of all, what the lender is going to want to do before anything and what the borrower is going to need the lender to do is to perfect the security interest in inventory. And I think most people know or have an idea of what that takes. And it's basically signing up a security agreement, making sure that there's some sort of value that's exchanged, and that's usually a loan with a loan agreement, and then filing a UCC. And at that point, a lender in just about every situation with inventory is, quote, perfected. However, if a lender's perfected, it doesn't necessarily mean that a lender's going to lend on that inventory because there might be other issues with that inventory. And maybe even to step back, and maybe this is getting a little too simple for you, but the purpose of being perfected is if there's ever a meltdown and you have to liquidate a borrower or they go into some sort of bankruptcy, the lender wants to make sure that the money that is recovered from the company in bankruptcy goes to the secured lenders first, and they want to be secured on your inventory, and that's the reason for perfecting a security interest. Having said that, when that happens, there could be other issues that prevent a lender from actually lending on that inventory, such as access to the inventory or intellectual property rights that prevent what they can do with that inventory, even if they do have a perfected security interest, and other issues that, while they are perfected, mean that they won't lend on it unless some certain steps are taken, and that's specifically what we're going to talk about right now. And the first and probably one of the most important issues they have is where is that inventory located? If the inventory is located at the borrower's location, and the borrower owns the location, and all they have to do is call the borrower and say, hey, we're going to come and get the inventory, that's the easy scenario, and there's really not much to do other than file that UCC that we just talked about, and you probably have access rights in a loan agreement or a security agreement. But what if it's located at a Bailey location or a warehouse? Or what if it's located with a customer because the customer is, taking the inventory as it uses it? Or what if it's consigned somewhere, or if it's commingled somewhere? Then the lender all of a sudden has certain issues that it's concerned about, and the borrower says, hey, I'd like to still include that inventory as inventory I can borrow on. How can I do that? And the first two areas we're going to talk about, because they're somewhat related, are good inventory that's located at a leased location. In other words, the borrower leases a location. They have a landlord. The landlord potentially has a bank or an owner, and there's a mortgage in place. We're also going to talk about public warehouses or Baileys where we don't store all of our inventory in our warehouse because we don't have enough room. We also, and maybe it's also because we store it around the country so we can get it to our customers more quickly. So we have public warehouses where we keep this inventory. And the question becomes, well, how can we actually borrow on that inventory? And that's where, Jason, I'll let you pick up and talk about what's important.
Okay.
I'm sorry, lend on that inventory, but Jason, go ahead.
Thanks, Jim. I think kind of just taking it one step back and kind of getting into our is it eligible, is you look at like a loan agreement which is based on these things, it kind of sets out eligible inventory. And kind of one item as we're talking about leased locations or third-party locations is there's kind of the general carve-out that inventory is not eligible, which means from a borrower's perspective, you can't borrow against it if it's located at any leased premises or if it's located at a warehouse at a third-party location. So there's kind of that general carve-out first. And there's ways to get then that back in, and namely, if it's a leased location, you have the landlord waiver. If it's a third-party warehouse, other arrangement, you'll have a Bailey agreement. And what I want to do is just kind of talk about what's contained in those agreements. Actually, both of them, although they're kind of structured and the language isn't identical, the same sort of concerns are in both from the lender's perspective. And then I think it's also important from a borrower just to know kind of what's in there so that if they need to shepherd the kind of negotiations along when the lender and landlord are negotiating this form, that there's some understanding of what's in there. The first kind of main aspect in both of these agreements is requesting the third party, whether it be the landlord or the Bailey, to waive their rights in the personal property. There's kind of a possessory liens, which are by statute, or these third parties are entitled to, and these are generally for storage fees, for rent, for processing fees. And so what you want to do is make sure that they don't have this, say a year's worth of back fees, and that would come ahead of you as a lender. So that's the first thing is the waiver of those rights. Generally, when you send out these agreements, it's a lot of times you'll have the third parties say, okay, you know what, I can agree to that somewhat, but a negotiated point often, or where you ultimately have discussions is there some sort of limit? Because they want to get paid, but what you want to do is make sure that it's some sort of limit that's acceptable to both the landlord and ultimately the lender. And what that ultimately means is if you have a certain day, let's say it's a 30-day window, what the lender's generally going to have to do is put a reserve in place because they could potentially be on the hook for that 30-day period, or the landlord would have rights in the collateral for that 30-day period. The next one is you want to try to address access rights. And this is, so you have your waiver of rights or waiver of liens from the landlord. You have your security interest, but you also want to know that you can enter these premises that are, in essence, owned by someone who's not a party to your agreements. And if there's a meltdown or something, you can get in there and whether it's liquidate or do what you need to do, whether it be a public auction, and basically ship those or enter the premises. A lot of things here when you're negotiating these sorts of arrangements is landlord or the third party wants some sort of rights that obviously you're going to pay them for service fees while you're in possession. From the leased premises, a lot of times it's also how long you're going to have the right to enter the premises. That's something that I think works well in connection with the appraisal, to make sure you know how long it's going to take if you have to liquidate. What you don't want to do is if the appraisal says it's going to take 90 days to come in, whether at an auction or something to that effect, you don't want to have agreed that you can come in and take possession for 30 days. So that's something where you kind of want to look in your reports, your field exams, things like that, to know what you can and can't live with. Then the final kind of item that is fairly important from a lender's perspective is if the borrower is in default under the Bailey agreement or the lease, what you don't want the third party to be able to do is terminate, basically kick the borrower out, and then if you're the lender, you're kind of out of luck and don't have access. So what generally you'll ask for is notice rights if there's a default, and then also the right to cure those defaults to the extent that they're curable if they're past due on rent. You have the right but not the obligation to, as a lender, to cure those defaults.
And I think the key to keep in mind, I mean, what Jason spoke about is a big concern in the angle he approaches from a lender's point of view. Hey, we would like to lend on this, but we need to get these waivers in place, whether it's the landlord waiver or the Bailey waiver. And as you probably surmise from what he's saying, they are negotiable. We have a form that we like to start with, but we'll work with the landlords to get something that works for both parties. From the borrower's point of view, you also want to have this inventory included in your borrowing base. And so what's important for you to make sure that it gets put in your borrowing base or to make sure that you can borrow on that inventory is to work with your landlord up front and early, either when you're negotiating a lease or a warehouse agreement, to say, hey, if we borrow money, we might need to put one of these agreements in place, and we want to make sure that you're going to act reasonably. Or if you already have your bank in place, when you enter into your new lease or your new public warehouse agreement, get that in place at the same time, because that's when you have the leverage. The most difficult situations arise when a company is entering into a new banking relationship and they've been leasing or renting space for the last 3 years, and there's nothing, the landlord has no right, or no obligation to enter into one of these agreements. And sometimes they try to extract a pound of flesh, or they do something because they know, hey, you as the borrower need to get this done. What can we do to make some money out of this? Your threat is always, well, we can do nothing and we'll just move our stuff, but that's really not always the easiest solution. So it's important when you enter into these agreements to keep in mind that you're going to have potential borrowing ramifications, and should we get stuff in place ahead of time. And I would go as far as to say you can even put in general access agreements that say, even though we don't know who our lender will be, we can put in an agreement that says you will cooperate with whoever that lender is. And those are unusual, but they will make your life as a borrower much easier when you are entering into that financing.
I think it's a great point. There's a couple things with the lease, although you don't see them typically. We've run into situations where a landlord has come out and said, you know what, that's great, but we have 5 more years on our lease. We have no interest in doing this. We're not required by our lease, and kind of take the hardline stance, where if you had a provision in your lease, kind of similar to, I don't know if a lot of you guys are in reading the leases, where there's requirements for kind of delivery of subordinations or estoppel certificates, almost something that says that the landlord will kind of comply with requests from the tenant's lender to negotiate a commercially reasonable form of a landlord waiver or a Bailey waiver. And that's not a guarantee that you're going to ultimately get something that's acceptable on the back end, but at least it'll prevent kind of the straight, yeah, you know what, we've looked at it, but we're not going to do it. You can kind of use some leverage to say, look, you've agreed that in the future you would use commercially reasonable efforts or agree to a commercially reasonable form. So it would give you some leverage there. Kind of the whole process of the landlord waiver, also getting into what can borrower do. I think when you're on the front end of a new credit agreement, it makes sense to get these out as soon as possible, one of the first things. What we'll generally try to do is get our form of waivers out in kind of our introductory email. The sooner you can get it in the third party's hands and have them start to look at it, the better, because it'll take a week or longer for them to kind of look at it. Then they'll get to it, get it to their attorney, get some comments. So it's important to get it out as soon as possible. And also, I think it makes sense, the borrower has the relationship with this third party, although I know that us or other lenders are willing to kind of negotiate or reach out to the third party landlord or Bailey's counsel. It really helps. We have no relationship with them, so it does help if you're a borrower to be kind of that, at least on the front end, and express why it's important and kind of reach out and let them know that it's going to be coming, because that can mean a lot, as opposed to just us as kind of unrelated attorneys sending it to them and talking to them, and a lot of times they'll kind of back off and not be quite as responsive.
The next area, and again, if people have questions along the way, I'll just reiterate one more time. Feel free to write them down and raise them. Is consigned inventory, and we'll also couple in with this commingled inventory, and Nathan's going to talk about it. But before he starts, most people, when they think of consignments, think of, oh, I have some goods, I'm going to go put them in somebody else's shop, and they're going to sell them for me and send me part of that money when they sell it. But what we're seeing more and more frequently, and it's sort of similar to a just-in-time inventory system, is companies that want to sell goods to customer X will put the goods on their location, sell them to them on consignment, and the consignment is, as the customer's using those goods in their assembly, they're paying for them. If that's the case, that's technically a consigned good, and there are certain steps that need to be followed to get to have a lender be willing to be perfected on those goods, but also lend on it. And Nathan, I'll let you take over.
And just kind of stepping back, the perfection also has a lot to do with kind of your priority. You can be perfected in something, but there's also then some of these steps will ensure that you have first priority and not kind of second or third. So that's kind of another distinction of what that perfection kind of will get you.
So with thanks guys, the consigned inventory is similar to the leased and Bailey locations in that you have a borrower, if you are a borrower, you have your own inventory at a third-party location. Where it differs, though, is that in a landlord or Bailey situation, what is going to end up happening is you're going to ship that inventory off under an invoice, and it's going to become an account receivable. Where consigned inventory is different is that you're going to ship it to another for basically sale or return. So it's either going to turn directly into cash or it's going to get returned and it's just going to remain inventory. So in order for you to be able to borrow against it or lend against it, depending on your perspective, there's going to be a handful of steps that you're going to have to take. The reason that this inventory is generally thought of as you're not able to use it to borrow against or to lend against is that it is in the hands of another party, so you have access issues. But in addition, and this is a point that I think is overlooked a lot, and it's one point where the UCC doesn't necessarily seem fair, although not much fun to read. The UCC does keep things come to pretty fair results. And the over kind of arching idea of the Uniform Commercial Code is that the person that is in the best position to give notice to the rest of the world has the responsibility to do so, or that person can lose out on its rights. And with consignment and commingled, which we're going to talk about right after this, the UCC has come down and they've said that even the owner, so this is really important even for business owners, even the owner of a good, if it's been delivered to a third party, has to take certain steps, or you can lose out on your rights to those goods, inventory in this case, to the third party's secured lender. So that becomes a really problematic issue, because even if you're perfected, which Jim and Jason have hit on earlier, you could lose out on the priority, which is what Jason just got done talking about, if you've not followed these steps. So the sort of solution to be able to include consigned inventory is that you'd want to get a consignee waiver. Essentially, that's going to be an agreement where you're going to have the third party represent that they're able to identify the borrower's inventory, that they're going to agree to grant access and to release that inventory, that they're going to waive or subordinate any lien that they may have. There could be a potential where the third party would have a lien for work done or money owed to it by the borrower. And then the last thing that you'd want in that agreement is for them to acknowledge the lender's lien and have grant permission for the lender or the borrower to file a UCC. The second step in the process is that you'd want to do lien searches on the third party. And the idea behind that is what you're going to try to do is you want to know if there are any secured creditor, that third party has any secured creditors. Because again, if they do, then you have to provide notice to them that you've delivered goods to them. Otherwise, you could lose out, even though you're the owner of those goods still. The third step is you would have, you'd file a UCC financing statement against the third party for that consigned inventory. And then if you're in a lending relationship, you assign that UCC to the lender. This is a very important point for companies that engage in these types of transactions. Sometimes when you're doing a lending transaction, the lender's lawyers, present this list of things that need to be accomplished. And you look at it and you go, oh, this just seems like a lot of lawyer stuff. I don't understand necessarily. Why do we have to go through all this? Why do we have to run lien searches on this third party? It doesn't make sense. Well, this is actually something that you should do, as I said, to ensure that you're keeping your rights in your own inventory and your own goods, regardless of if you're in a lending relationship or not.
And
These are steps that need to be taken.
To back up, that initial financing statement that you file names the third party, so who's actually in possession of the goods, as the debtor, and then the owner, so the borrower, as the secured party. Mm-hmm. There's no financing. It's really just because of the relationship. So that the lender's borrower is named the secured party, and then ultimately the lender gets protected when that financing statement is assigned. But that's a good point that from a borrower's perspective, even if you're not even in a lending relationship, this should be something that you should do to make sure that your rights in that property
right,
don't
because what would
disappear.
happen is if the third party you've delivered your goods or inventory to was to melt down or go bankrupt and they had secured creditors, those secured creditors are going to come in a liquidation, and they're just going to see a bunch of inventory. And if they are an all assets secured creditor, then the UCC has determined that they weren't in the best position to know that not all that inventory was theirs. So they have the rights under the UCC to that inventory ahead of a company that's delivered on consignment, even though, and again, initially you think, boy, that just doesn't sound fair. They're mine. I didn't sell them. I didn't get any money for them. Title never transferred. But again, you were in the best position to give notice to the rest of the world. So as Jason said, what the filing is a notice filing. You're telling the rest of the world, I'm delivering this type of inventory to this third party from time to time, and then anybody else that's going to loan money and come in and be in a situation to liquidate is going to have to do so subject to that notice. The fourth step, and I'll just review since we sort of talked about that step for a while, you have the waiver agreement, you run the lien searches on the third party, you file the UCC, and then if you're in a lending relationship, you would assign the UCC. And then the fourth step is, based on those lien searches, if that third party had any secured creditors, you got to provide written notice to those existing secured creditors that you from time to time are and will be delivering inventory, and that inventory remains yours, and that they won't have any rights to it. If you follow those four steps, then you don't run into that situation where the third party's secured creditors rights could trump yours. Is there any questions on that? I know that can be a little bit confusing. Okay. The second topic that sort of relates to that is commingled inventory. And commingled inventory it's a little bit different because what it is goods that are physically united with other goods so that the original identity is lost and a new product results. And there's really two ways you can get that result. One is an example, very simple, but flour and eggs to cook a cake. If you had an interest in the eggs, you don't have an interest in eggs anymore because they don't exist. The other way that you can have commingled inventory or goods, you think of ball bearings from 10 different people all get delivered to one processor, and that processor just dumps them all in a bin, one giant bin. There's no way to identify those specific ball bearings that you delivered any longer. The problem is similar, though, that what it is you have inventory in the hands of another person. So again, just like with the consigned inventory, the processor's secured creditors' rights could trump yours if you don't follow certain steps. There's still the access issues. There's an added issue of the product being unidentifiable in some instances. And then because this is a processor more than just a third party that's holding it to sell on your behalf, it's also more likely that the processor will have a possessory security interest for work that's been done on those items. The UCC handles this situation a little bit differently. If you had a perfected security interest in the goods or inventory prior to it being commingled, then you have a perfected security interest in the resulting product. If there was more than, and so that's your perfection. Then the second step of that is, well, where do I fall in the priority? And the priority, if there's more than one secured creditor, then everybody that was perfected prior to the commingling is still perfected, and they rank equally in proportion of the value of the collateral. So basically, in order to get the benefit of that rule, then what you would need to do is similar to the consigned inventory situation. Processor waiver, same type of lien searches on the processor, file the notice filing against the processor, and then written notice to any of the processor's existing creditors. There's an added issue that you could identify in the processor waiver that might help you avoid only having a proportion of the resulting product, and that would be if you could come to an agreement that they are subordinating their the lien in the resulting product to the lender's lien. It would just be a case-by-case situation on whether or not you'd be able to do that. And then another sort of fact-specific issue that may arise is that if the processor does have a secured creditor, it may be to your benefit to enter into an intercredit agreement with that secured creditor so that again, you could determine between yourselves and not leave it up to the UCC who is going to have the sort of priority in the security interest. Does that relate to this?
No, go ahead.
And then even more, so as a continuation of commingled inventory, there's it's a separate category, but it's called an accession, and that's basically inventory that's just like commingled. It's physically united with other goods, but in a manner where the identity of the original goods aren't lost in the resulting product. So, not that any of us know what widgets are, but using widgets to put together something and the widgets still exist, that would be an example of an accession. The problem here, similar to the other issues, you have inventory that are hands of another party, so they're going to be subject to the creditor liens, any possessory interest of the processor, and you still have the same access issues. Now, the rule under the UCC is a little bit different in this situation. If the security interest and the inventory was perfected prior to becoming an accession, then it remains perfected in the whole to the extent that the secured party has a security interest in that type of collateral. So just as a quick example, if you were a secured lender and you had only secured on software, but then that software gets put into a computer, then so you're not perfected on goods, your filing doesn't perfect on goods, then there would be an argument that you would no longer be perfected on that software because it's an accession to the new resulting good, which is a functioning computer. So then the real difference here is in the priority. Remember, under a true commingling situation where the identity is lost, you have priority in proportion with other secured creditors. Under this rule, the priority is determined by the other rules of the UCC. So, for example, first to file or PMSI rules. So this, in that way, it's very much like it's very much unlike the commingled goods, in that you could lose even if you were perfected and had first priority in the inventory as it originally was, but then once it becomes an accession, you could lose on the perfection issue if you didn't have an all assets filing, as an example, or on the priority issue if you both were secured on all assets, but the other person had filed ahead of you, then you would lose out on priority. So the solution is the same as with the commingled goods, except that it's imperative in the processor's waiver or the intercreditor agreement, depending on whether or not they have a secured creditor, to have a subordination of liens and determine amongst yourselves who is going to be first in priority in the resulting good.
So I think the point there, and we got a little bit technical, and I'm sure your heads or most of your heads are spinning right now, is we can work things so that a lender can have a first priority perfected security interest on at least certain parts of inventory if they're commingled, on all of the inventory if it's consigned. It takes some work. I'm sure that most of you sort of understood some of what Nathan was saying, but we don't expect any of you to walk away from here as experts, but just understand that there are ways we can do this, and from a borrower's point of view, it's a way to get more of your, again, I'm going to continue to repeat this, more of your inventory into the borrowing base. From a lender's point of view, it could provide you a strategic advantage to winning a deal by saying to a borrower, hey, we can actually lend on an inventory that maybe one of these other lenders wasn't able to lend on. One of the questions, and we have a few, and we'll kind of get to them as we go through the program today, is I think there was a little confusion on the consigned inventories and the UCCs. If you are selling goods to a customer and the goods are being shipped to their location and they're consigned, so they're using them as they use them, then before you even worry about lending, you as that seller should file a UCC so that that person who's holding your goods, your customer, their lender doesn't think they own those goods. So before you as the borrower even worry about your bank, you should absolutely have a UCC in place to let the lender of your customer know that those goods are yours, not your customer's. Then, once you do bring your bank in place, and if you want to borrow on those goods, then what you do is technically take that filing that you should have already made and just assign it to the bank so that they would get the proceeds of those goods. So I hope that answered the question, and if not, let me know. The next area, which is also one of the questions, is what about in-transit inventory? More and more inventory, and we're going to talk about both domestic in-transit, and domestic is both Canada and the U.S. While Canada has its own separate set of laws, it generally adheres to and recognizes U.S. law for U.S. issues. So when I say domestic, I mean Canada and the U.S., but there's also a lot of goods that people have coming over from China, from India, from Europe, and from other areas, and they want to know, hey, well, these goods are on a ship for 3 months, or I'm sorry, maybe 3 weeks across the Pacific or Atlantic Ocean. Can we borrow on those? And the answer is yes. And the first part, and I'm just going to walk through these areas quickly instead of handing them out to the guys to my right, but for international in-transit inventory, you can borrow on those goods and you can lend on those goods, but you have to have specific things in order to do that. And I'm going to go through those items, and I'm not going to get into too much detail, but I'm going to give you the 30,000-foot view. And again, if you have questions afterwards, please come and talk to us or during this. The requirements to lend on goods that are coming from another country are, number one, you have to have title to those goods. So if your borrower is, if you're company X and you're borrowing, you have to be able to show to the bank that we, in fact, own those goods. Secondly, those goods coming across the ocean are going to be subject to a bill of lading. We're going to want that bill of lading to be a negotiable bill of lading. So if you're the borrower, you just have to work your systems out so that you're getting a negotiable bill of lading versus a non-negotiable bill of lading, because while the lender here is perfected on those goods under U.S. law, if that boat would get diverted from, it's coming from China and it gets diverted to another country, and I'll just use Japan as an example, although I don't know how Japan would actually handle it, Japan may not recognize Ohio or the United States UCC law. They may only recognize international law. And under the international, and I forget the exact name of the law, most, if not all, countries are going to recognize negotiable bills of lading, and whoever holds those negotiable bills of lading is the owner of those goods. And that's why a bank is going to require that you have a negotiable bill of lading. The third thing we're going to require, and this is for all goods, all times, is that they're insured. So we're going to want to make sure that there's some sort of marine insurance that covers any catastrophe that would happen to those goods as they're coming across the water. And last but not least, you're going to have, unless you're a huge company that has your own people that do this, and I haven't come across one of these companies yet, there's going to be a customs broker or somebody at the port that is going to handle the logistics of taking those goods off the boat, getting them through customs, and then putting them on a truck or a train. And so just like Jason and Nathan have both been talking about these landlord waivers and consignee waivers and bailee waivers, what we'll do as a bank and what you're going to want to do as a borrower is make sure that you can get a customs broker agreement in place where the customs broker can continue to work with you, the borrower, continue to let you run your business, but what they'll do is have a provision in there that says if there's a default in the credit agreement or there's some sort of liquidation, the bank gets to call the customs broker, give them notice that they're taking over, and then they will start to direct the customs broker. So they can continue to say, hey, send it to this customer, we're getting paid, or no, we want you to send it to this other place. So those are the 4 items that you're going to want to have in place to get eligibility for what we call on-the-water in transit inventory. Sometimes, if you look at a credit agreement that, like Jason talked about earlier, has the definition of eligible inventory, another thing that gets kicked out as ineligible is any in-transit inventory. So it's not just on-the-water inventory, it's also if it's coming from Canada to the U.S., if it's coming from California to Ohio, if it's on a truck, or if it's on a or on a train. And can your lender give you credit for that? And the answer again is yes. And the requirements this time are similar to on the water, although you don't need a customs broker agreement. You do need to show that you own it. You do need to show that you have insurance on it. And you actually want a non-negotiable bill of lading for the domestic goods because you don't want anybody else to hold a negotiable bill of lading that shows ownership. You want it to say it's owned by my customer, my borrower, and this is where it's going. And as long as it's within the Canada or U.S., you know that if it got diverted anywhere, those courts are going to recognize our law, so you're okay with the diversion if it does happen. And that was sort of a quick overview of in-transit, but it is becoming a much more hot topic, so I'd encourage any of you afterwards or even after today, if you have these issues, to give us a call, and we'd be happy to discuss more about your situation and whether it's something that it's possible to borrow against. Let me take 2 seconds to read a couple questions. That's yours. This question, I'm going to read a little bit because I'm not sure that I quite understand it. But while I'm looking at this, and we may step back to this question, I'm going to go ahead and, to keep the program moving, we're going to talk about now goods that are at your customer's location or in one of these other locations, and we've gotten all the steps in place to make sure that we include them, but they're licensed and have intellectual property rights attached to them. And Jason, I'll let you go ahead and work on that.
Yeah,
We'll
and
discuss
this is kind of an important thing and we'll get into kind of what the concerns are. But one example is, as Jim said, is licensed goods. And as a father of a 3.5-year-old and a 1-year-old girl, the example I use is pretty much everyone in my life. Let's think the borrower has a license with Disney to manufacture some goods, and there's Disney princesses, which I think I've bought pretty much everything that there's possible can have Disney princesses on them at my house. But there's concerns there because there's rights of the borrower, of your borrower as a lender, of what they can do with that inventory. There's certain probably restrictions on resale, whether it be that only the manufacturer can sell them, that they can only be sold through specific distribution channels, that there's royalties that might need to be paid on each item sold. Maybe there might be certain quality standards that need to kind of be adhered to. And then there might be certain penalties if these things are violated, whether it be that the license is terminated, that sometimes you'll even see as far as that any of the goods need to be returned to the licensor for basically a nominal charge. So these are things from a lender's perspective. You really want to kind of understand what those kind of restrictions might be and how that's going to affect how you could liquidate the inventory, what restrictions are there. And the best way to do this, the kind of primary step, is to request the actual licensing agreement. Look at it, see what kind of restrictions are in place, see how this affects ultimately the value of the inventory. Because for most of the times it'll probably reduce it, or it severely restricts it, and maybe it allows you to not be able to loan against it at all if there's a straight restriction and you're stuck to go through certain channels. So if you look at that and then kind of get a good feel of what the restrictions are, one thing that you can kind of do is enter into an agreement with the ultimate licensor. This could be difficult, but if it's valuable and it's something the restrictions are burdensome, it could be worthwhile to go to the licensor and get an agreement that, look, the secured party is able to sell these products, and what you'll probably do as a lender is have to be subject to the certain distribution channels and making royalty payments. But the big step is being able to just first sell them. You're probably not going to get a blanket right to sell them for whatever price and through whatever channels, but at least you'll get some sort of consent that you would be able to sell them. The one thing I think that a lot of times you'll have some discussions with are past due royalties. So you'll agree as a lender to pay for royalties going forward as you sell them, but what you want to be careful is not to be kind of a guarantor of all past due royalties, because by the time you get there, you could have 12 months of past due royalties, and you don't want to be on the hook for those items. Kind of related to the licensed goods is you have kind of, I guess, prepackaged or private label goods. This is another question of kind of value. The prepackaged goods is, I guess, the best way to look at this, and I'll give an example, is let's say you make bolts and you sell those to Lowe's. And actually on the package it says Lowe's on the package. So obviously you're, as a lender, or if you come in, you're not going to have probably the ability to come in and sell those to other parties. The other thing is the private label, which is where the product itself would have a brand name on it. So probably even more limited, because you can't just open the packaging and sell them to other parties. This is just more of a question, I think, of value and of what you can do with this inventory. To some extent, it could be a benefit because you kind of have a built-in distribution channel and someone who you can sell them to, although maybe they're not required to purchase them. At the other side, it could be kind of a detriment, just because you're not free to just sell them to whoever they want. So those are just certain things to consider. I think you need to look at the underlying agreement for those two to see what the restrictions are, kind of what things are in place, what are the mechanics for those private label prepackaged. But I think it ultimately comes down to really what value do you put on those kind of that inventory in a liquidation proceeding.
And again, just to be proactive, like when we discussed sort of your landlord agreements and your rental agreements, if you're looking to borrow on these goods, make sure you have all of your license agreements handy. Sometimes we ask borrowers, well, can you get us, you're printing books and you put Disney on there, where's your agreement with Disney? We need to review it to find out what we can actually do. And it takes a month to find that. If you want to borrow on these goods as a borrower, make sure you have all your documents in order, and your bank's attorneys are going to have to read them to see what rights they'll have. And then when they work with the appraiser and everybody else, they can talk about, does Disney do they have to buy these goods back? That'll help. Do we have any rights whatsoever? Back to the valuation. If we can pull those screws or bolts out of a box that says Lowe's on them, what are those bolts worth alone? Because that still might be something that you can borrow on, and as a lender, it might be something you're willing to lend on. So just keep those things in mind as you move forward. The next area that we're going to spend just a couple minutes on perishable goods, most lenders, the first thing you're going to say is, okay, they're perishable, we can't lend on them. And we also know there's some liens out there that the actual farmers and distributors have on those goods, so we're stuck. There's really nothing we can do. And I think what Nathan will tell you is, while that's not completely off base, it is a little bit more difficult to lend on these goods, or sometimes a lot more difficult. It can be done as long as you keep in mind what are the liens or the reserves you might have to put in place and other issues that are out there. So, Nathan, go for it.
PACA, the Perishable Agricultural Commodities Act, it covers fruit and vegetables, both fresh and frozen, so long that they haven't been processed in a manner that changes their nature. Just an example, cherries are covered. The cherry filling for pie is not. Basically what happens is that through this act, the sellers of produce have been protected so that there's a lien for each unpaid seller all the way through the chain of distribution. And this is a priming lien in favor of that seller, so that it would trump a lender. So as Jim said, at face value, it definitely looks like inventory that you probably wouldn't be able to borrow from, or as a lender really want to touch. There are a couple of technical ways that you may be able to get outside of the act, but I think it would be very hard to monitor. And if the payment terms or whatever the sort of technicalities were that you were trying to do, if the borrower didn't sort of maintain those terms, then you would fall back within the act. So the real alternative is to reserve against all the trade payables that you would be including in the borrowing base, or for the inventory that you'd be including in the borrowing base. And it's important to note that if you, as a lender, needed to liquidate that inventory under the act, you would be you'd have to pay the full amount of the trade payables, and in some cases that can be greater than the inventory, the related inventory. So you basically just want to make sure that you have a good enough reserve, high enough reserve amount in place. So basically it's going to end up coming down to a business decision of whether or not it's worth, after putting in reserves in place, to include them.
Okay, and then, that's a good segue into what Alex came for, which besides was just to sit up here and look good during the presentation, he actually has a couple of things that we are going to run into now. And the first is there a value? There's definitely going to always be some inventory that is ineligible. But as a lender, can you get comfortable with some value in that, and will it help you maybe not include that in a borrowing base, but include, have more boot collateral that's going to maybe give you some reason to do an airball or an over advance or some other form of lending that could enhance the credit? And as a borrower, is it something that you can do to also enhance what you're borrowing against? So, Alex?
Well, after listening to you guys, I would say there's no value in any of it because it's so difficult to get at it with all the hoops that you have to go through. But no, there is some value in people ask us as an appraisal firm, what do you think should be ineligible? And that's a difficult question for me to answer because there's no good answer. Sure, should slow-moving inventory be ineligible? Sure, because if the mix of the inventory gets worse over time and you have a trigger in there where you have a reserve against slow-moving inventory, that's going to protect the loan. So that's a good thing for the loan structure to make that ineligible. However, if your goal is to get as much value out of the assets that you're trying to loan against, there is value in slow-moving inventory. So from one perspective, you may say it's better to make it ineligible, and in another perspective, you may say, I want to know what that's worth. I know it's not worth a lot, but what's it worth? So as appraisers, I never know how to answer that question. We like to work with people and understand what your motives are and how you're trying to structure your borrowing base. We try not to get involved in those decisions because we become an advocate for one side or the other by doing that, and that's really not what an appraiser should be. An appraiser should try and be neutral, and by making ineligible decisions, you become an advocate for one side or the other. Back to the topic, what types of ineligible inventory can have value? Well, slow-moving inventory certainly can have value. Finished goods that are selling over 12 months are not likely to be worth zero. They're not going to be worth a lot. Obsolete inventory can have a value. A lot of inventories have a scrap value, so there's almost always a value there. A few, clearly in the work in process. If you're looking at a loan and the work in process is 100% ineligible, and you're trying to see if there is any other additional value there for whatever reason, unconverted bulk goods that are saleable as is ought to have a value. An example would be a roll of paper, a roll of liner board at a packaging plant. Unkitted work in process that's essentially finished product. We talked about the Lowe's hardware. Well, before the Lowe's hardware got put into a bag, probably that was work in process, and it was finished hardware and perhaps a bag and perhaps a label, and it was all put together. Now, you may or may not want to kit something in a liquidation, but certainly kitting something it should be low-skilled labor, and perhaps that's a way to get in some additional value out of that inventory. Hidden finished goods, meaning the company's reporting systems, there are actually finished goods in WIP. That's one of the most common places to find an ineligible item that ought to have value. Consigned inventory is an interesting topic because we often, depending upon the lender, whether they've gone through the steps that were outlined here and made it eligible, or just on principle made it ineligible, it's interesting that there's a lot of appraisals out there where the exit strategy is to sell through to the customer base. And the customer base consists of 20% of the goods being sold through some kind of consignment arrangement. So on day 0 of the liquidation, you assume that you're not getting anything for the consigned inventory. And then on day 1, we ship more inventory off to that consignee. Well, they better pay for it, I guess, because you're not going to sell it through consignment. But it's an interesting issue as to how do you continue to sell in a liquidation to an ineligible position. A warehouse, you're making a warehouse ineligible, yet in order to ship something to your end customer who's going to pay you, you may have to ship something to that warehouse. It's not an ineligibility issue, but as an appraiser, it's something that we have to think about and wonder, how is our exit strategy going to take into account the fact that the lender doesn't want to make anything eligible at that location? Well, you may have some negotiation to do at the beginning of the sale, or you may have to refigure it out how you're going to do it. Other hidden value items, fuel oil at a paper plant, often ineligible, it's often bunker C, it often has fuel value. Black liquor at a paper mill has a fuel value. So there are oftentimes fuels and whatnot that are routinely part of a supplies inventory and considered ineligible, and there's no really good reason for them to be made ineligible other than it's traditional, just because they have a high value. What else would be there? Anything that has some type of predictable scrap value, and I don't mean a penny or two, but a steel casting would normally, if it isn't overly complex and hasn't been machined, will normally retain about 30% of its scrap value, normally, depending upon what the type of material it was made out of. So there are things that are, have a routine and predictable scrap value. Some of the other topics that were brought up here, I just wanted to comment on, and they relate to some of these ineligibles. If you're, I'm sorry, just I'm going to start that over again. So if you're making, well, that goes to the second topic a little bit more, but on the.
Well, while you're thinking about that, let me actually bring up a thought that I had that you made a good point and with value. And one of the things I guess we really haven't focused on during this presentation, but I think it's important to know from a lender side and from a borrower side, is there is a cost to doing this. So if you have $10,000 worth of goods that are on consignment, you're probably not going to want to go through the legal process of getting those goods included in your borrowing base, because the legal fees may end up costing, and they're not going to cost 10 grand, but they could cost enough that it's not worth it to you to include those. So while our goal today was to talk about some of these other areas of items that we can include in borrowing bases, there is a cost benefit. So as a borrower, I don't want my lender friends to come up to me afterwards and say, I'm going to have 50 borrowers coming up to me and saying, why aren't we borrowing on this? There is a cost, and if there's not enough there, there's a business decision that needs to be made on the cost and the benefit. And from the lender's point of view, I also don't want you to go to your borrowers and say, we can lend on all of this stuff, because again, the cost is not necessarily great, but there is a cost in whether it's time or legal fees or appraisal fees or other things, insurance, whatever. There is a cost, and there's a lot of good cases to be made to put these things in your borrowing base, but it's not 100% of the items 100% of the time. So just something to keep in mind.
Yeah. A couple other things that are routinely made ineligible, it goes to the off-site issues. Something like a dross, an aluminum dross or whatnot, some kind of product that's being shipped off to be processed, and there's an arrangement with that processor whereby it's going to be converted, and the product that's going to be returned is really a commodity. In the case of aluminum dross, it would be aluminum ingot. In the case of chopped wire or whatnot that's insulated, it would be copper ingot and whatnot. Those types of inventories are routinely made ineligible, and really, for a very nominal processing cost, you're going to get an asset back that is pretty much a COMEX traded commodity. So I mean, certainly a dross inventory, you would have to take into account the offsite issues and make sure you were perfected on those, and you'd have to take into account the further costs of processing it, because I don't believe any of those waivers would insulate you from having to pay whatever processing fees were incurred from the point forward from which you took possession of it as the liquidator or as the bank taking possession of your assets. So in other words, you'd have to cover those costs, but normally those costs for processing are pennies in relation to the value that's there. So there are lots of areas of traditional ineligible inventory that aren't necessarily going to make your loan. They're probably not going to turn your loan in from, if it's got a major problem, it's not going to rescue it. At the same time, they may make your borrower feel like you're on their side a little bit or working with them and not making every little last thing ineligible.
Okay, and then I guess the last topic that we're going to talk about today before we wrap up is reconciling value between actually appraised value of inventory, which is what Alex's firm is doing, versus the audited value. And I'll just go ahead and hand it right back to you, Alex, and let you discuss that.
Sure. So again, this goes back to the most common areas where there are issues is things where general reserves are being looked at by the audit team, such as slow-moving inventory or obsolete reserves, where the calculation of that reserve is either done on a periodic basis and not necessarily being done at the time the appraisal is being done, or it's conducted in some kind of general fashion and not at the item level. That brings up a reconciling issue to a good appraisal. A good appraisal is going to look at the inventory at the item level. And so if something is supposed to be ineligible because it's slow moving, you're going to calculate, if it's 12 months, you're going to calculate that amount of inventory being ineligible. Or if there's an aging cutoff whereby everything over 9 months is supposed to be ineligible, the appraiser should be looking at it at the item level. And oftentimes, the general calculation of ineligibles of aging or turnover or slow moving won't tie exactly to that calculation unless the appraiser and the audit team are using the same data set. So that's an issue. A second issue where appraisals don't tie to an audit is if you have this aging reserve and the auditor is calculating the aging reserve on the general ledger, and so they have a $250,000 aging reserve, and then there's a location in Peoria that's ineligible, and there's another $50,000. Well, the appraiser is looking at the item level, so he knows that he made something ineligible, and lo and behold, it is also in Peoria. He made it ineligible because it was aged, and he made it, and then it was in Peoria, but he's not going to make it ineligible twice because he's already counted it once. So you do have issues where an audit team is looking at things on the general ledger, and the appraiser is looking at things at the detailed level. And then, of course, timing issues are a critical issue, or any other type of generalized reserve. You know, as an appraiser, we spend a lot of time trying to try and get it to tie out. And certainly, if it's a complicated inventory with a difficult reconciliation, I would recommend that the appraisal firm and the audit team are doing their work at the same time, and they each get the phone number of the other person so that they work together on it, because that's really the only way to make some of those more complicated deals work out in that fashion.
Okay, and at that point, we sort of end.
I just want to, I'm sorry. do you
Go for
mind?
it. No, absolutely.
What two other little things here. On ineligibilities, when you have rental assets, which are kind of machinery and equipment or inventory, oftentimes people don't consider the rental stream that may be generated during a liquidation prior to the liquidation being over. So if you have assets out on rent and they generate rental receivables, theoretically those rental receivables are going to be generated during the liquidation for a period of time. I would recommend looking at that. It may or may not be something you can consider depending upon the services that are required for that rental operation. If it's a passive rental operation where simply the asset being in the field at that person's site and there's no interaction with your borrower, I would say you could consider that rental stream as an asset that you could potentially loan against. The second thing on tying things out in terms of deposits, if you're looking at a company that has deposits or progress payments on an asset, and you're making deposits ineligible, you might want to double check that there's inventory associated with that deposit. In other words, I don't believe, and the attorneys could probably help here, I don't believe you're going to have to worry about a deposit with no inventory assigned to it or attached to it or associated with it. So we often, our deposit calculation of ineligibility will often be different than the audit team's calculation of deposit ineligibility because we try and tie the deposit to the asset. And then, sorry, just one last thing.
Go for it, yep.
So we got a question regarding terms in a liquidation. And the question was phrased, we are doing an appraisal and the client has asked that we assume sales to existing customers are at terms, not cash. This has increased the gross OLV. Have you seen this request from your clients? We rarely see that request. We do consider looking at terms in a liquidation where it makes sense. And what I mean is that if the liquidation is most likely to occur in some fashion where terms are going to be offered to the major clients, we talked about the Lowe's issue. If you want to sell that hardware bag to Lowe's, well, you might, and Lowe's is a fairly good, well-rated credit, you might want to consider selling some of that inventory on terms to Lowe's as part of your liquidation strategy. So if it makes sense to sell with some limited terms to some of your major customers, if you're going to sell to Walmart, you're going to have to do it through terms if you want to have a liquidation to Walmart. And so there are times where it does make sense to offer terms in liquidation. And I think if it doesn't make sense or it's unnecessary, I think the answer would be no. You would refuse it. I would say that it really shouldn't be something coming from the borrower. It should be something that the appraiser should recommend if they think it's necessary to run the liquidation. And that's it.
And there's two other questions. One had to deal with current trends in the market, which I think we could spend another hour on. So whoever wrote that question, if they'd like to come up and talk to one of us afterwards, we'd be happy to give you the 30-second update and then maybe set up a time to get together to talk about that in more detail. And then there was another question regarding purchase money security interest. And again, I think I'd be happy to discuss that question with somebody afterwards. I'm not sure that it appears that there may be an apple and oranges issue there, but I'd be happy to discuss that with whoever wrote that question afterwards as well. I hope this was helpful. I hope at least at the very minimum it raised things for you guys to think about, things of ways to help or additional ways for you to help improve what you can borrow on. I would suggest for those of you out there who are borrowers, talk to your lenders first. I'm sure they've got ways they can help you, and the goal is to get you to get better terms for what you can, and so your first step is to talk to your borrowers. For those of you who are lenders and borrowers, if you have appraisal issues or wonder if there's value, please call Alex. If you have questions about, hey, what about this inventory, whether you're a borrower or a lender, can we lend on this? What does it take? How difficult is it? What cost is involved? Please feel free to call any of us up here. And we're always happy to pick up the phone and talk to you. We don't start the meter running. We just want to get you advice, and hopefully it leads to a relationship in the future, but we're happy to give advice when you call. And unless anybody else has any questions, which I don't see, thank you again for coming, and we look forward to seeing you on the next one. Thank you.